Okay, my name is Clark Adams. I'm in our applications record section here in Salt Lake, and I work in our public inquiry section. I've been with the division about 25 years. The last 3 years I'm in Salt Lake. The previous time I spent 22 years in our Cedar City regional office. So I have a little bit of different perspective of some parts of the state. As we go through, if you have any questions, please raise your hand, and if you can wait for a microphone, and I'll even try to answer the questions. But we do have a panel over here to make sure I don't spew too much false doctrine during the day. I'm going to be talking about the water right process, and I know that sounds really boring, and it kind of is, but has anybody here filed an application with our office? Okay, one or two hands. It's usually not just sticking a piece of paper in the machine and letting it grind out and it spits out in 5 minutes and you get an approval. A lot of people like to come into our office and in 5 minutes have an approval to go drill a new well. But we are governed by statutes and policies and administrative rules that we have to go through, and sometimes it takes quite a bit of time to spit out that approval, if it can be approved. And we're going to talk about that, this process today. And we're going to try to build on each other. Will went over a lot of good things, and like Boyd said, you're going to hear these same concepts again and again throughout the next 2 days. And probably after about the third or fourth time, your eyes are going to get kind of glazed over and wonder, why did I have to hear this? But let's see if I can figure out how this works. Okay. So how do you get a water right? There's different ways. One of the ways that Will talked about was an application to appropriate. In areas of the state that are open for appropriation where there's still water available to get, you can file an application with our office to obtain a water right. You could purchase a piece of land that has existing rights on it. And if the people selling you that property don't specifically reserve that right, then that would transfer as what's considered an appurtenance to the land. But through a title action, through a deed, the seller can reserve that water right. So you want to, if you're purchasing something, you want to make sure how it is described. You can also purchase a water right separate from land. In one of the, I don't remember which 18 whatever land act that came in, land can be separated from water. And so in this case, in Utah, it has become a commodity where you can purchase a water right and transfer it to another piece of property, subject to the different rules and policies for that area. Don't expect to purchase a water right in Logan and hope to use it on your home in St. George. It's limited to usually the drainage area where that water right is existing right now. We'll talk a little bit about a couple of terms, perfected and unperfected. You hear these terms a lot. I mean, people ask, what is a perfected water right? It's one that has been proved up on, has been put to beneficial use, has been decreed. When a water right has gone through an adjudication process and it is included in the proposed determination or decree, it's considered to be perfected. Or a water user's claim that is issued after an election's been filed by an applicant, it's considered to be perfected. And when a diligence claim has been acceptably complete and submitted with our office. An unperfected right would be kind of the same thing. It would be just the opposite. It has not been certificated, it has not been proved up on, it has not been decreed. It may be an application appropriate that proof has not been filed on as yet, and a certificate has not been issued. An unapproved application to appropriate is unperfected and is considered only a filing, and the water right cannot be used until it is approved. And a water user claim that has been published in a proposal that has not been published in a proposal determination or an unaccepted filed diligence claim would be considered unperfected. So we talked about a lot of these different applications, and I'm going to go through some of the most common ones that we have and review in our office. And I'm going to cover why we file them. In the later presentations, we're going to be talking about how to. Sometimes we're going to talk about our diligence claims, applications to appropriate, change applications, exchange applications, and temporary and fixed time. But why do we have so many different types of applications? Because there's a lot of different scenarios that not every scenario can fit the one you're in. You may be in an area where there's no water that can be purchased, but it is open for appropriation. So you would file one. Or you inherited a piece of land that was used by your grandfather, and you've been using it for stock watering for 120 years. You could file a diligence claim if that right has not been established. And these are not all the forms we deal with, all the types of applications. There are a lot more, and with any other good bureaucratic agency, we're always coming up with more. And throughout the process, we have staff that are willing and ready to help you, because there's a whole new lexicon of terms and what you're going to be going through, and you may be new to this whole process. We'll kind of talked about this a little bit. Is the term we use is accept complete. In order for us to be able to accept an application, it needs to have some basic information. We need to know who the owner is. We need to identify the source of the water, the flow or the volume, the description of where the point of diversion is, if it's going to be a well or a spring or off the Green River, where on that river you're going to take that water, what the existing or intended beneficial uses are going to be, where it's going to be used. We need an application map, and then all the owners would need to sign the application, and everyone's favorite part, there is a filing fee. If any of these are missing, we may not be able to accept the application, and it would delay things moving forward. Let's talk about the first one, diligence rights. Sometimes people call them pioneer rights. It's when these are recognized as rights that were put to use for surface water prior to 1903. And why that date is important is that's when the state legislators, our governing body, enacted the legislation to say that the state, in order to get a water right, you have to apply for it. But it recognized everyone using it prior to that 1903 date. So you would have to file a diligence claim to establish the right that you have been using continuously. It could have been we had a question from Moab. It could have been in 1902. It could have been in 1850 or 1870, whatever date you could establish when that water was first put to use. In 1935 is when the legislation came into effect that governed underground sources. So if you had a well prior to 1935, you could file an underground water claim and establish that right if it had been in continuous use. A diligence claim is filed with our division for review, and there are statutory procedures found in section 73.513 that we follow. Today, in order to file a diligence claim, it has to be prepared by a licensed land surveyor and engineer. And they must provide some basic information. They need to tell us who first put the water to use and how you are the successor in interest to that original user of the water. And how to do that is to provide us a chain of title, copies of deeds, going back from how you got the property all the way back to the original claimant. You need to tell us who that person was and provide a flow measurement and a map of the beneficial use. The most important thing about a diligence claim is these uses have to have been in continuous use since 1903 for surface water and 1935 for underground sources. And one of the hardest things you have to do now to provide is evidence of that the water was put to use before 1903. Usually we have required in the past personal knowledge, and it's getting harder and harder to find someone who has personal knowledge of water being used in 1903. So we've accepted city and county histories, family journals have provided us evidence, but sometimes we've had to say no. I reviewed one several years ago down in southern Utah, and the furthest back they could provide evidence for us was that they owned the property in 1944. And the evidence of use for the spring was they gave us the history of a sheep association that said the sheep were watered on Cedar Mountain. But there was no evidence tying it back to this property. And we said, until you can provide that for us, we could not accept that diligence claim. We went back and forth for a lot of time, and as far as I know, they still haven't been able to provide that evidence. So if you can claim and show that use has been continuous since before these dates, you can probably file a diligence claim to establish that use. And everyone's favorite part of a diligence claim, there is a filing fee. So incomplete claims. Do you have a microphone? And this is so that our people in the remote sites can hear.
Yeah. Well, just for clarification, so you would be needing to file a diligence claim if you were buying new property, or you wanted to assure that you had the water rights?
If there are existing uses on your property that you are purchasing that you cannot find a water right that has been established, and if you can show that that use has been continuous since 1903 or before, and you can provide that evidence, then you could file a diligence claim. It doesn't have to be a direct family tie, but you need to provide some kind of evidence, and it can't be secondhand. It shouldn't be, well, my uncle told me or my grandpa told me we've been using this spring. We need to have something that ties back to establish that claim. And
I had a question on that case that you talked about on Cedar Mountain with the spring. So if the people owned the sheep before, was it 1947? That's what you said, or
1944.
44. The sheep would have to drink from the spring, correct?
But there are several thousand springs on Cedar Mountain, and they could not establish saying that the sheep association used this property to water these specific sheep, because it was a co-op where everyone kind of commingled their sheep in herds and moved around to different fields, and the association had already established rights on other springs, and this was a private right trying to claim a cabin that was built in the 1980s as a domestic use. And so they could not prove or show any kind of evidence that the sheep had gone through this area. And there was just, we always look for a preponderance of evidence, the 51% that we can say, yeah, okay, we agree with it. They could only go back to 1944, and then this loose this history that said we watered sheep on Cedar Mountain.
So then what happened to the water right on the spring?
There has not been a water right established. We gave him an option to find a water right that he could purchase and then transfer to that spring, but we could not accept a diligence claim as he had filed it.
So did the valve get shut off in the meantime? So did the valve get shut off in the meantime? How does that work? If you think or suspect there's an issue and you file, are you going to be in more trouble than if you just stick your head in the sand?
If you use the water without a legal water right, you are subject to enforcement. And it's been up to the regional office whether they want to move forward on this diligence or an enforcement action on this one. I've been away from this one for a few years, so I'm not sure if they have purchased a water right to make the use of the spring valid. So, and our enforcement engineer is pretty busy with other things too. So we have, I shouldn't say we have bigger fish to tackle, but we'll see if the family continues to After after a diligence claim is filed, it is advertised in the local paper. This is for us to give public notice to anyone who feels that this new claim may interfere with their existing rights. If people feel that this is going to interfere with them, they can submit a protest. And a protest to a diligence claim is a little bit different than any other protest, and we'll talk a little bit more about protests in a little bit. A protest on a diligence claim should be filed with the district court, and because this is establishing a legal, it's a judicial determination of the validity of the claim, and the courts have been very clear that the state engineer does not have judicial, that we don't have that authority. We may hold hearings on or information gathering on a diligence claim to gather information to better understand the application. We'll do a field investigation, and we would also prepare what's called a report of diligence claim. That would be part of our public file on what has been found. We reviewed another one several years ago. They were claiming about 2 acres of irrigation that has been used historically from some springs. As we went out there, about 1 acre of that was a sandstone outcropping, and we could not figure out how they grew a vegetable garden on sandstone. So in our report, we established that we recognize that this right should be limited to 1 acre about 1 acre of irrigation, because you can't irrigate sandstone. Okay. And we have a question, James. He's getting his steps in today.
Sorry.
So one more question. You mentioned 1980s on this cabin. I don't want to beat a dead horse, but 30 years of water use does not constitute a right?
It does not. And illegal use does not establish a water right. I think that's kind of clear.
I had a different question.
Okay.
So you're talking about the protest period and the filing and the notification, and you showed the drainages on the state map, the other guy did, on the state map, and you can divert a water right from one spot in that drainage to a different spot in that drainage, correct?
In some cases, each
Well,
drainage may
The
have.
reason I'm bringing this
Okay.
up is I've seen this happen. It's been approved, and it was put in the local paper for approval, for anybody to protest it, where a water right was bought in far, on a river and then moved on top of a mountain where there's no water.
Okay.
So, or very little water, we'll say. There's very little water. There's some water. How is that approved? I don't understand that, because there's other water users in that area, and obviously if he took, like, say, 1 acre foot from down at the drainage at the bottom, there's not even that amount of water at the top. Do you
Okay.
get what I'm saying?
Yes.
Just like there's more water up in Weber versus down in St. George or,
Okay.
Landing.
And this is kind of a generalized map of kind of the appropriation policy for the state and the different areas. Each area has its own individual policies. And there are times when you can take a water right that originates in the bottom of a drainage and move it to the top. And the theory behind that is the water that falls on the top of the drainage will eventually flow down and cause recharge down in the bottom. So it's one big happy drainage system and aquifer. There are areas in Washington County where that area is divided up into, there are some regional administrative boundaries that you can't cross to bring a water right from the headwaters of Ash Creek and take it to down to St. George, or St. George up to the New Harmony area. And even and we look at how where the like groundwater divides may be, where drainage breaks are going to be. So there are cases where you can take it from the valley to the top of a drainage, and there are times that you cannot. Our regional offices are local experts, and they look at each of these areas very carefully when they establish the policies, whether it's going to be open and where you can move water to. The Utah Lake drainage area, Utah County, Salt Lake County, there are policies where you can move water from Salt Lake County down to Utah County because of everything is connected through the Jordan River, and it's divided up administratively into different areas, but we have policies where you can move between drainage areas. So I guess the short, boring answer is it's area specific. But if you feel that, if someone feels that it may interfere with their water right, and we're going to talk very specifically about protests coming up in a few minutes.
So what if the protest period's already passed?
The question is, what if the protest period is already passed? Through our office, you probably couldn't do anything. You may find an attorney that could take it through maybe a legal action, civil action, just to prove that there's been some interference. But it gets limited if people miss the protest period on our end. And I hope I'm not making our false doctrine people uncomfortable in the answers here. So, okay, I got it. I'm doing okay. Yes.
What you said,
Yes.
30 years of stealing water doesn't give you a right.
Yes.
Misappropriation of water that should have never occurred shouldn't give somebody a right, correct?
Well, how are you defining misappropriation?
Okay, if you have a water drainage and it only has so much water, yeah, at the bottom, there's a lot of water, and then somebody took that, and I understand the logic behind that, but you could apply that to the whole west, since most of the water goes into the Colorado River. But, I mean, at the top, there's not very much water, so you can't just take, you know, the 10 acre feet and put it into an area that barely has 10 acre feet and say, well, what about all these other people that already have a right there, and say this person is upstream of all them, they're going to end up taking his water, their other people's water, I should say. You see what I'm saying?
Yeah, and that's where the priority date comes into it. And also, let me give you a specific example. Down by the town of Beaver, they have, up the canyon, there is a ski resort. And the development is happening where they want to get more water up there so they can build more infrastructure, more condominiums for people to come. There are very few established water rights in the Elk Meadows or Eagle Point, whatever the ski resort's name is nowadays. And so the people developing it have not been able to buy water in that area around the ski resort to develop it. They have reached downstream and found water rights of the highest priority, in that area it's 1870, and they are being able to move some of those upstream because the 1870 rights are usually always satisfied. And so we look at the priority date of the application that's being transferred, and we also look at the priority date of the change, the date that a water right moves into an area. We can look at that for localized interference. But again, it's area specific, and I know there was a lot of heartburn, a lot of hearings, and when the water was moved up the canyon to Eagle Point, just down I-15 a little bit in Parowan, the Bryan Head Resort was doing the same thing. They were struggling to find water. The issue they have in that area is the Parowan Irrigation Company owns almost all the primary rights on Parowan Creek, and they could not find a water right to move up the canyon to cover additional uses. Some agreements were made with the irrigation company to make sure that they were whole, and some surface rights were able to move up the canyon. So I want to make misappropriation. I mean, I'm not going to say we've never made a mistake, But these transfers are looked at very carefully on where they originate from, where they're going to, and how things are going to be, if someone is going to be interfered with.
I know you need to get moving on with the presentation, but Michael in St. George has a quick question for you.
Okay?
He says, just to clarify, if I bought a parcel of land on the mountain that had a spring that had always been used to water livestock, if it's never been proved up on, can I be in trouble for continuing to water my livestock?
You need to have an established right to legally use any source of water in the state. So if they can't find a water right on a spring that has always been used, then it becomes up to you to find a water right, or to move into that, or to, if you can file a diligence claim. Okay. All right. And if we need to, we can beat this horse some more. But we have a lot of forms on our website. This is our, if I can read that, this is our application to appropriate. Let me see if I can get to the right one. Okay, applications to appropriate. In areas of a lot of areas of the state are closed to new appropriations, but there are still some areas of the state that have limited development of the groundwater resources and surface water resources, and so they are considered open. But each one has its own unique policy. Some areas of the state may be completely closed for any new applications. Some may be open for large. There is other state you can come in and file for enough water for 120 acres of irrigation. There are areas of the state where it's open just for small domestic filings, enough water for a home, 10 head of livestock, and somewhere between 1/4 and 1 acre of ground, depending on where you're at in the state. Some areas are closed. All surface water right is considered fully appropriated, but you can still apply for an underground source. Even in areas of the state that are considered fully appropriated and closed, if you can show that you're proposing a project that does not consume any water, or that it would be non-consumptive, they could still be approved. Something like if you're going to divert water out of, say, the Jordan River. I don't know why you'd want to, but if you wanted to, and for a hydroelectric facility to generate power, and as that water goes out of the Jordan River and generate electricity back into the Jordan River, that there's no loss of the water, and you're not going to interfere with anyone else's water rights, an application like that may be able to be approved. Usually an application to appropriate is approved when you can show there's immediate need for the water and it's not for speculation or for monopoly. Here's just a quick map of the state. The area in green are areas that are open for appropriation. The areas in yellow have restricted policies, and the areas in red are considered closed for appropriations. But this isn't a perfect map. We have a more specific policy maps on our website. You are welcome to talk to us, and we'll walk you through it. There's another great picture of one of our forms. The next one I'm going to talk about are change applications. When you have an existing right and you need to transfer it to a different location, or you want to propose different uses, you can file a change application. And what a change application does, is to modify some aspect of an existing right. We talked about what a water right is and different aspects of it, the location, the point of diversion, uses, place of use. If you're going to change any of those aspects, then you could file a change application to move it to a new piece of property and drill a new well, as long as it's within the policy for that area. If you want, say, you're tired of raising alfalfa and you want to raise alpacas, you can file an application to convert some irrigation to stock watering.
Would that be a permanent change application? If you were going to build a house?
Yes. The question was, would that be considered a permanent change application? If you are going to make this a permanent infrastructure, it would be considered permanent. And we're going to talk about temporary applications in a minute and kind of the difference.
Sorry, we just have a quick question.
Yes.
And we're not sure if this is from St. George or Moab, so we'll call it St. Moab. But it says, can appropriation in a closed area can be approved for high flow times for extra water? Example, Area 73.
Yes, we have accepted applications, and one of the examples they're talking about is in the 73 area, Coal Creek, around Cedar City. We have accepted an application to appropriate high water flows, and they were filed in 2015 or 2014, and that's where the priority date comes in. As long as all other water rights are satisfied, and until the flow in Coal Creek reaches a certain point, they cannot divert any. But about once every 10 or 15, 20 years, there is a large flood event where a lot of water comes down Coal Creek, and they want to divert it and use it, and sometimes for some irrigation, I think they want to do some recharge projects with that. So in areas you can, but your priority date becomes the date you file that application, and you will be junior to everyone before you can get any of that water. Hope that answers St. Moab's question.
Coming back to he mentioned, is it permanent? So if you change the depletion, and you go for a lower depletion, and you're okay to do that now, or are you permanently stuck now with the lower depletion?
If you change the uses and you certificate that water right, the uses that you certificate, those are the depletion for your water right.
And become the new ones?
And become the new ones.
Even if the old one was better?
Yes. We've had, I won't say with tears, but we had arguments about this, about things have been certificated, and the depletion amount became less, and they wanted to convert it back, and they were not allowed to, because that's what it is certificated and used for. We have a state engineer with a big heart, but we are governed by statute on what is limited.
You can't retain that in any way, shape, or form when you supply or submit?
The question is, we can't retain that in any shape or form. The only way you could change it is if you filed a permanent change application, is if you withdrew that application prior to before you certificate it. Once it's certificated, that becomes the basis and the limit of the water right. Okay. 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 You can, if you file an application to appropriate and you decide, well, I messed up, I don't really want my well here, I need to move it over to the other South 40, you can file a change application on an approved, unperfected application to appropriate. And what that does, it amends what you're changing on the application to appropriate. It doesn't change the priority date, and it doesn't change the proof due date. So that proof due date is always running. And I think in the next presentation we're going to talk a lot more about proof. So that's a little term to keep in your head right now.
Moab asks, does a change application for point of diversion keep the senior right first in time, first in right?
The priority date of the water right will not change if it's being transferred. We talked about but the priority date of a change application may come into effect when you transfer that into a new location. If it starts interfering with other people's wells and water rights, we may have to look at the priority of that change when that came in. You may be limited if you are interfering with other rights. But the priority date of the water right will never change in most cases. We have let me just give you one little bit of hope here. If you have a well that has gone bad and you need to replace it, and you stay within 150 feet of that where the old well was, and you abandon the old well, you do not need to file a change application to replace that. And great news, there's no filing fee for that until the legislators find out about it, that we're not charging for that. But if you move 151 feet away from the old well, you need to file a change application.
So you don't have to file any application if you move within 150 feet?
You do have to file what's called a replacement application. And that's just a note, that's how we keep track of where, make sure the old well is being abandoned. If you want to keep the old well and the new well, you have to file a change. But if you abandon the old well, you just have to do a replacement application. Okay. There's another great form. There are many times that we have water right that has been bought and sold, and then we have multiple owners on it, and it has been used historically for an old farm, and they decided we're not going to farm anymore. We're going to sell off pieces of the water right, and so we get multiple owners, and in order to file a change application on it, you can only file on, well, everyone, the owner of that water right needs to sign that change application. If there are dozens of people on there that you don't know, you don't want to have to chase them down to file an application. So what you can do is you can segregate your portion of that water right. And we do a lot of segregating. There are a lot of different reasons that we're carving up a water right. When it is split up, you are assigned your own separate water right number. And people will, you can do it to separate the interests of your water right, so you can file a change application, or it's just if you're going to file proof on your water right, showing you're going to try to certificate a portion of it, but you have not fully developed all your water right, but you want to file proof on what you have done. You can segregate that portion and file a proof on that. You can, if you have shares in an irrigation company, we can do what's called a share statement to divide up your if the company will allow it. Let me put it that way. And we have a question.
Yeah, when you got irrigation shares, may an individual shareholder sell his shares, say 20 shares, to a municipality 5 miles away without the company's sort of blessings, or can they just sell shares independent of the water rights?
Yeah, okay, I just got the note. We're going to talk more about shares tomorrow, and usually the buying and selling of water rights or water shares, we don't get in the middle of. And each company has their own policies on what can be, how they can sell. And so we'll talk more about that tomorrow. But if you have shares in a company and they allow it, you can file a share statement with our office and file a change application based on those shares, and drill your own well or develop a spring. And sometimes people just want to segregate their water just because. So they want their own unique water right, not touching anybody else's water right, so you have your own water right number.
That's based on irrigation company policy.
For irrigation shares, it is based on irrigation company policy, not us. Okay. Not all segregations are easy, or they can be kind of complicated. Some of the reasons we have problems with segregations is not all the owners have signed it, or the title has not been updated into your name yet. We haven't received a copy of a deed that is when you've purchased a water right. If there's a pending change application on a water right, that needs to be addressed, how much water is going to be taken out of that portion. If there's a CFS and acre foot amount, it needs to describe how much is coming out of each one, out of the flow and the volume. I know this is a busy slide, but these are the kind of things we look at on a segregation request. And I don't think there's any questions on this. So, but there's a lot of information that we use to make sure segregation is done correctly. Okay, we had a question about moving water to the headwaters, and this next application kind of addresses this. An exchange application is one that is usually based with ownership. Let me back up. It's usually based with doing. That's the best way to say this. It's dealing with like a conservancy district. The Weber Basin Water Conservancy District has a lot of water rights, and they store water in several big reservoirs. And an exchange application is based on a contract with a conservancy district or other entity that has these water rights, and that the contract says they will deliver you 1 acre-foot of water based on their water rights, and you can exchange that to file an application to move it to your piece of property. And their part of it is they will release, you can develop 1 acre-foot on your property, and they will release an acre-foot of water out of their storage reservoirs to make the downstream users whole. So in cases where there's a conservancy district, an exchange application can be done to move it to the upstream tributaries within that reservoir. So it's not making water, and we have the commissioner, we try to balance how much water is within that drainage system. So hopefully that makes sense. If the contract, if the applicants don't meet the conditions of the contract, that the exchange would cease, and it would revert back to its prior uses. Okay, sorry, we're going to move through a couple of these kind of quick. Let's talk quickly about temporary applications. We do temporary applications to appropriate. They are usually they're valid for 1 year. You cannot file an extension on them. They are a lot of times used for projects that are just going to be short-lived, like road construction, oil, or mine exploration. You can do a temporary change application on an existing right to transfer a portion or all of a water that you own to another piece of property. It's done quite regularly. People will lease a portion of their water right to another farmer who may not have enough water right for all the irrigation he wants to do, so he leases part of it. They file a temporary application each year to cover his extra uses. If all or portion of a water is transferred by temporary change application, that portion transferred can only be used where the temporary application proposes it to be used. You can't lease 100 acres and keep using your 100 acres. You've got to give up something to get something. And so that you must abandon the use on what is being temporarily transferred. Okay. The last application we're talking about is fixed time applications. These are ones that you can file for any use on a fixed time basis except domestic use, as outlined by statute. Filing proof is not required. A lot of times these are filed for longer term projects, but may not be permanent, such as a mine. They may be able to mine out of there for 15 or 20 years. So a fixed time application is approved for a 20-year period. And if at the end of that 20 years, the mine is still producing, you can request an extension to be filed, and it can be approved as long as the proposed project. I'm losing my train of thought here. As long as things are the essential purposes of the application are still being used for mining, oil exploration. For a short time, they were allowed to do it on some domestic uses in the Salt Lake Valley when the people were needing water for homes, and there was no municipality close by to serve them, and they were approved with the condition that once the municipality reaches out to where they are, they had to abandon that water right and hook up to it. That's not being done anymore, and so don't ask. Okay.
Clark,
Yes,
could I add a clarification there?
please do.
There are two conditions to continue a fixed time application. The primary purpose has not been fulfilled, or the water remains available. So if either of those things change, then they won't be extended.
Okay,
So for instance, we've done many on the Colorado River because we're not using our full allocation, but there are enough approved applications out there that at some point we probably will be, and so those fixed time applications will have to go away.
okay, thank you. Okay. We'll talk a little bit of flow chart here and on what the process goes through. Or this is our organization chart, so now you know why I got picked to do this one? No. Okay. Our application process, it's not complicated. Some people have called it the black box. This is it. This is what we go through. I know you bring your information in, kick it to us, and it kind of grinds away, and we try to kick it out. We're going to talk about this first part, which is the filing and the review of the application. And so it's where the application is filed. We notify the public. We address any protests. We review the proposal in relation to any other water rights, and an initial recommendation is made by the regional office. We'll talk a little bit about staff consultations. The legislature felt it necessary a few years ago to amend the change application statute to let everyone know that we will consult with you. But we've always done that, and we always will. It is specifically in the change application statute, but we have applied that to any application that comes before our office. And there's a good divide it between a pre-filing of application and a post-filing. Before you file an application, come in and talk to us about anything. We can talk to you about the review of the requirements, the potential issues, and give you any kind of information. After the application has, any consultations are not binding on the applicant or on the state engineer. Sometimes we hear what we want to hear, and I've heard many times, well, he promised me it'd be approved. And there may be things come up that it cannot be approved. Post-filing of an application, we need to be very careful, especially if an application has been protested. We should not have any what's called ex parte communication, which means just for one party. If the applicant comes in and says, well, my neighbor protested and I don't like that, but we should still approve it because I'm a good guy. Or the protestant comes in and says, you don't know how bad this person is and you should not approve this. We do not want to have any consultations without both parties there. Recently we had a hearing, and I received a phone call a couple weeks after the hearing, and it was one of the protestants complaining about the decision-making process and other things that we should know about the application. And I tried to tell her several times that we should not be having this conversation without the applicant present, and she continued on for about 45 minutes. What I did afterward is I wrote a letter to her, to the applicant and all the protestants to let them know that we had this conversation. We don't want any appearance of favoritism. This is an open process, and so we let everyone else know. I let everyone else know that we had this conversation happened. And if discussions drift into specifics of an application, our staff is directed to let everybody know. Okay. Filing an application, you can do it by mail in or personal visit. We'll be happy to sit down with you and go over things. We'll be happy to take the required fee. Filing an application will establish the initial priority date of the water right or the application, and it is placed on our we have a new filings list that you can track every new application that's filed on our website. Okay. After an application has been filed, the regional office will review it, make sure it's complete, and they'll designate it for advertising. And applications are advertised in the local papers, in the county where as local circulation of the paper, of the location of the proposed point of diversion and place of use. If it's a complicated application, we may advertise it in more papers. We recently had one filed, and we advertised it in 7 newspapers, 4 in Utah and 3 in Colorado, because that affects a few things going out of state. Some small filings, temporary applications, we have the authority that we can waive if it's non-controversial. We can waive advertising. But just because an application it is not advertised, it is still subject to review and protest. And we'll talk a little bit more about tracking and what has been filed in a future presentation. Applications are protested once a week for 2 weeks. And and this is by statute that we have. But we have to advertise these. Temporary filings lasting for less than a year can be advertised at the discretion of the regional engineer. Temporary change applications are not advertised per statute.
Is the advertising also posted on the website?
Yes, it is. There is an advertising list that you can look at by county, by newspaper, by name, and you can track all that.
Have you guys considered not using newspapers since people are typically not reading newspapers anymore?
The question is, have we considered not using newspapers? I bet we've considered it, but we are required by statute. This is how to give public notice. You can look there's a website called utahlegals.com where all the legal notices in the state go into there, but that is not, right now we can't use that as a legal notice. It has to be published in the newspaper of local circulation. The filing fees for the applications cover part of the advertising costs and the processing costs of the application. And the newspaper will provide us what's called a proof of publication that we have to receive. Okay, we're going to talk, I know we're running out of time. We had a lot of good questions early. Protests, if an application is advertised and at the last day it is advertised, each application is given a 20-day protest period. They have 20 days from the last day of advertising to submit a protest. Usually it is someone who may feel that this transfer of water would interfere with their existing rights or may be impaired by the project in some way. Sometimes title or property access or environmental concerns are brought up in protests. Protests should not be based on how well or how much you dislike your neighbor. It shouldn't be. It should be based on statutory requirements. Sometimes we have received general protests. We want to protest everything in an area, but a protest must be specific. Just a quick example, we had an individual several years ago that was protesting every application in an area. And unfortunately, he had to file an application on his water right. So to be consistent, he protested himself. And the application was still approved. Applications must be, or protests must be timely. They must be received within the 20 days within 20 days after the last day of advertising. And this is to establish legal standing for the protestant in any subsequent application procedures or potential court involvement. Protest, it cannot be anonymous, and we cannot accept general protests. And it needs to be signed. And we appreciate if the names are printed so they could be legible. There is a $15 fee for each protestant. If a group of individuals all come together and file a protest, but only pay $15, we will only usually list the first person on that protest as the official protestant. If everyone wants to be considered an official protestant, everyone would need to file their own $15 protest fee. The only exception is a husband and wife will just charge you once and give you a break there. They can indicate whether you want a hearing to be held. And again, the only exception with a protest is with diligence claims. An official protest contesting the validity of a diligence claim must be submitted with the court. And to make life easy, you can now submit protests and pay for them online through our website.
Hey, Clark, why don't
Yes.
we take our break right now? And then
I'm on a roll.
so let's take our 15-minute
Okay.
break right now that we're gonna have, get to use the restroom and whatnot, and then we'll come back to you and we can take some questions during the break as well. So.
Okay. I know I'm over on my time, and we're going to just, these next couple of slides are going to, hearings are going to be covered really in detail in another presentation. Okay. And the decisions that Teresa will be covering a lot of this. So let me get to the approval criteria governed by statute, the reviews done by the application records section, and the state engineer's action. But let me get to this point. After a decision has been made, every application is approved saying that it is subject to reconsideration. And what that means is if the applicant or a timely protestant does not like the decision that has been issued, they can ask for reconsideration and saying, hey, state engineer, you didn't look at this, or I don't like how this is done, and there's some information you didn't have when you made your decision. And it has to be timely, and you have to have legal standing to request reconsideration. So that's why a timely protestant, within that 20 days, you have to, it has to be in. You have a question?
Yeah, is that calendar days or is that?
That is calendar days. Okay, it's 20 days from the date the order is signed, and every order has the date it was signed. And those orders are, when the date they're signed, they are mailed out that same day, and they are scanned and put on our records. If once someone files for reconsideration, our office has 20 days to say yes or no that we're going to accept the request for reconsideration. If granted, the original decision is rescinded. If it was approved, it goes back to an unapproved status. If it was rejected, it goes to an unapproved status. And at a later date, after review of the information that's been provided, an amended order may be issued addressing the reconsideration request. The reconsideration, the amended order may change the requirements and the quantifications of the first decision. It may indicate that the review of the additional information or the concerns, it does not need to change the original decision, and then so initially it would be the same. In some cases, it may negatively or positively alter the ability of the application to meet statutory criteria if new information is brought in. If the parties do not agree with the amended order, they can submit a timely court appeal. And if the request for reconsideration is denied, the decision on the original order remains in place, and parties not agreeing to the original order could pursue a timely court appeal. So that's the 20-day reconsideration period. It is also have a 30-day appeal period, and the 30 days is appealing directly to the district court. Parties with legal standing, applicants and timely protestants, can appeal the state engineer's decision and order to the district court having jurisdiction in the area of the water right. The appeal must be timely, must be submitted within 30 days. It must be submitted within, okay. I can't use both hands here, so, but I'll work on it. The appeal must be made within 30 days of the issuance of the original order, or 30 days after the request for reconsideration has been denied, or 30 days after the amended decision is issued after granting the reconsideration. So if you don't like it and want to take it straight to the court, you can do, it has to be done within 30 days. The court does a de novo review, and that's a good Latin lawyer term that means starting from the beginning. the de novo review process is not a process to find fault in the state engineer's decision or the process how we came to our decision. It's a new look at the application. It looks how this application applies to statute and the policies, and this new review is done by the court rather than by the state engineer's office. The district court can uphold the original order, they can deny the appeal, or they can amend the order. And or it has been in the past, it can be kicked back to the state engineer to look at it and try again. If parties do not agree with the decision issued by the district court in an appeal, they can still appeal it to the Utah Supreme Court. Okay, I'm getting really close to the end. Unfortunately, this is a picture of me. And yes, that is the state seal on the side of that truck. But a couple of things I learned on that day is you never let all four wheels go into the mud. Never trust a Ford in the mud. And sometimes the mud is deeper than it appears, even on a nice clear day. It does, it's nice blue sky out there. But one of the things I learned is know who to call and to help get you out, even if they'll hang it over your head for the next 20 years. And consider yourself delayed but not stuck. And never let a coworker bring a camera into the field with you. We get a lot of inquiries on the status of applications. If you filed an application, if you have any questions on where it is and feel it's not moving along fast enough, feel free to call our regional office or our public inquiry section and we can walk you through. We just got to be careful on, let's not get into the aspects of post-consultation or post-filing, saying, you guys need to approve this because. If there are problems with the water right or the application, feel free to give us a call, and we'll try to give you direction and try to getting the application moving forward. We do try not to have any applications stuck anywhere, and we try to move them along, but we are governed and limited by state statute, and that's a better picture than I had. But we are limited to. Oh, you took all my last two good slides away. That's okay. But we do try to take the applications as they come in order. And a lot of times we get requests saying, hey, can't you just move my application ahead? But please remember, if you're in Disneyland, you should probably ask the 200 people behind, or that's going to be behind you want to jump in line, if it's okay. So we try to move them along as we get them as they're filed. So, so I really had two really good slides left, but that's okay. But the rest of this hearings and some of the review is going to be covered in a subsequent presentation. So that's what I have. Chris is up next. Does anybody have any questions before we move on? Great. You can beat up Chris now.